Hartsock. I'm the director of the IU Center for Bioethics and of the Bioethics and Subject Advocacy Program of the Indiana CTSI. And this is our next installment of our bioethics of our translational research ethics applied topics talk series. These are meant to be short, 20 to 30 minutes, although some people go longer. Introduction to a key topic in research ethics, often bordering on regulation, for researchers and for people who have an interest and want to know about a topic, a basic introduction. These are then posted on our website, through the CTSI, on the Center for Bioethics website, with linked resources for people to learn more later. And always to call us or email us at the Bioethics and Subject Advocacy Program, BSAP as we call it, for consultations, which we are always very happy to provide related to these kind of presentations. So it's my pleasure to introduce Jane Hartsock, JDMA. She's a faculty investigator of this center. That's actually the longest standing, well, I think that's your longest standing position on your slide.
I think it might be.
The first position you got.
Yeah.
She is also, very importantly, the director of the IU Health Department of Ethics, in charge of ethics at the Academic Health Center and
That's
beyond.
right. No, just the Academic Health Center.
And she's also an adjunct professor in medical humanities and health studies. It's a great pleasure to introduce Ms. Hartsock, Esquire. Is that the right thing? For our talk on research without consent.
All right.
Counselor Hartsock.
Oh, we're having fun today. All right.
Fun was just beginning.
So, so the idea behind this talk is to discuss an area of medical research arising out of the clinical encounter, and the sort of fuzziness of knowing when and when you do not need consent of the individual for research or sort of arising out of that interaction. And just some brief objectives. We're going to review the historical context of research, the research treatment distinction within the context of consent. And so the purpose of doing that is mostly to make the argument, or at least to excuse how messy this issue is and why it's so messy. Then to identify some concerns of informed consent in individual and combination settings. So what I mean by that is individual meaning consent in treatment versus consent in research versus consent in research arising out of treatment. And then to clarify the regulatory guidance on the requirements of research in the clinical context. And I think I am going to need the video thing on the side is there a way to adjust that?
You can minimize it.
Okay, because I otherwise will not be able to read my own slides. And I need them. Okay, so the reason that I decided to do this talk was to use it as a deadline to get a handle on an issue that is coming up right now at our own health center, which is the consent, the ostensible consent to research that is contained in our general consent to treatment. So when patients come into a clinic or the hospital within Indiana University, they sign what is called a general, consent to treatment and patient responsibility agreement. And the first paragraph of that is entitled Authorization for Treatment, but includes this, which is I understand the hospital is a research and teaching institution, and my body parts, not so much brains, sometimes, including organs, tissue, bone, and bodily fluids, may be used for teaching and research purposes. And so for those of you who are maybe not regularly interacting with patients, this paragraph actually causes a lot of trouble for us. Patients don't like it. Clinicians don't know how to respond to patients' objections to it. We are unsure why it's in there and what it actually does. And so the concern would be, as we sort of move through this talk, that several concerns, that it disrupts the therapeutic relationship because it makes patients unhappy right at the outset of their interaction with a physician. That it gives clinicians false comfort in research that they would do, thinking they can rely on this for the research that they might do in the clinic, which they cannot. That's where I will end, but I also want to be clear. And then just the sort of like confusion as to where did this come from and why is it here? So along that path, I said I would provide a sort of argument at least for 3 categories of consent relevant scenarios. The treatment scenario, the non-therapeutic research scenario, so those would be the sort of more typical research studies that sort of like advertised on the bus, do you have diabetes, come in for research, that sort of thing. And then the combined research treatment scenario that's more modern now, and it's tied largely to biobanking, issues of biobanking, issues of data collection, biospecimen storage, and that sort of thing, which is really specimens obtained during treatment and used in research. So that narrow category, not narrow, right? I mean, it's a huge category of research now. So I've also identified some primary concerns or foci, in each of these 3 categories. These are my own observations based on reading the literature and the case law associated with each of these categories, that if I had to sort of thematically identify the priority for consent in each of those things, I would say that the concern with consent in a treatment scenario is informativeness, whether the person is informed, with the rationale being that they need to be informed in order to calculate the risk-benefit analysis of treatment, with benefit being the thing that distinguishes treatment from research generally, benefit to the patient. The most well-known case on this is the birth case, which is almost a cliché at this point, but was a woman who consented to a pelvic examination under ether. This is a case from like 1915, I think. She consented to a pelvic exam, but explicitly withheld her consent from any surgical procedure done while she was under ether. And the physician did a surgical removal of a tumor anyway. And so she sued the hospital. She actually ended up losing because she sued the wrong entities, which is sort of irrelevant. But the ultimate legal principle that comes out of this is that if you do not obtain consent, you committed a medical battery. So then we have our non-therapeutic research category, where the focus is an emphasis on voluntariness, that the person who's there wants to be and agrees to be and is free of coercion. And the rationale for that being that they are assuming a risk, understand the risk in the absence of a presumed benefit. And that's the sort of well-known category of the Nuremberg trials and Tuskegee syphilis studies and Willowbrook school experiments and all of that. And a standard that is articulated from the Nuremberg Code, it's the first paragraph of the Nuremberg Code, voluntary consent is absolutely essential. And then our third category, which is really going to be what we're focused on today, which is this combined category where the research is being done either as part of treatment or arising out of clinical care. And my thematic categorization there is that the concern in those cases is a potential conflict of interest, which might disrupt the fiduciary obligation of the physician to the patient, and that your example of that, the prime example of that, is the famous Moore case of the patient who had hairy cell leukemia and was treated extensively by a physician who was actively pursuing a patent on a treatment for that condition, and ran a number of tests and obtained a number of biospecimens that arguably were not part of treatment at all, and didn't tell the patient that those things weren't necessary for treatment. So moving forward, just to begin, the kinds of consent forms that we use here at IU Health are pervasive. They are used in almost every academic health center to some extent. Ours seems to be a little bit more explicitly attempting to consent for research, whereas some of the other ones, as you can see here, consent to be contacted in the future for research. Cleveland Clinic, consent to be contacted in the future for research. And then this is Brown University's Medical Center, that things might be removed and there might be quality improvement and scientific research done as part of the treatment there. So I don't mean to just pick on our institution. This is really pervasive. So where did it come from? As I said, I think it arises out of the lack of regulations in the early part of the 20th century, middle 20th century as well, and the resulting lawsuits then that that came because there was no real regulatory guidance. So Henrietta Lacks is the sort of famous case of the person of an individual whose biospecimens were obtained and used in research without her consent. Her family feeling that they should have been compensated for part of the financial gain as a result of that research. Important to understand one of the distinctions there that matters subsequently. The individual who obtained the specimens from Henrietta Lacks, Dr. Jones, was not the individual doing the research. So as we think about our regulatory guidance, it's questionable whether the Lacks scenario, which we all, I think, have some initial questions about, would actually even be impermissible today. It probably would have been permissible under the common law. Then we have the famous article by Henry Beecher from 1966 in the New England Journal of Medicine, identifying multiple cases of clinical research in the clinical setting where consent had not been obtained or had not been properly obtained, and that being kind of a watershed paper exposing the issue. And then Thomas More, I always do that, right? It's too much Catholic school. John Moore, his lawsuit against UCLA was brought in 1990 for care that he received in the late 1970s. And the court in his case agrees with him that he should have been advised of the potential conflict of interest of the physician who was both doing the research and providing his treatment. He's awarded $1 for that nominal damages, which allows the court to identify a new principle of a legal requirement for informed consent, even in the absence of any real identifiable damages to the person. So, so I think what happens here with these forms is that in the absence of any real regulatory authority, lawyers, freaking lawyers, right? Decided that we probably needed to insulate ourselves from research. We needed to provide some kind of insulation for claims similar to Moore's, and the way to do that was in that initial treatment consent form. So, so these forms just kind of emerge over time, and they're picked up and used in hospitals. They're absolutely ubiquitous. So the question is, do they, in today's contemporary research settings, mean anything or do anything? And so my answer would be, I think, no. And that answer is tied to these two big questions, which is, when is informed consent to research required? And then in the cases where it is, what is required of informed consent for research? So to address, these are questions that are answered in the common rule. And so research consent is required anytime there is human subject research, defined in the common rule as research being done on a living individual involving the intervention or interaction or in which you obtain identifiable specimens or identifiable private information. And so you can imagine how these scenarios then go in a clinical setting. If you have an oncologist, for example, who is involved in a clinical trial of a medication on patients whom he or she is seeing, and so they are both the treater and the investigator, and they are drawing the blood. They know who the patient is. They are reviewing the medical records. They are changing treatment depending on these kinds of things, where there's essentially no screen between the researcher and the patient, or even sort of less formal things. I mean, when I'm talking to my students, I sometimes joke about how frequently people are involved in research that they don't even necessarily identify as research, sort of the informal thing of, I'm going to try this communication approach with my patient and see if it works, and then if you're planning prospectively to publish that or to offer that up as actual research, then it really should have IRB approval as human subjects research. So, so the intervention or interaction, the close connection between the person who is being studied and the person doing the study. And if we draw then the distinction between Moore and Henrietta Lacks, you start to see that become, I think, illuminated a little bit better. So in the Lacks case, her obstetrician was Dr. Jones, who obtained a biospecimen from her cervical cancer, sent it down to a lab where it was de-identified, and Dr., I think his name is Guy or Gay, was the person who actually did the research and developed the cell line and promulgated the cell line. So there was a distinction, there was a sort of semi-screen between those two individuals. John Moore, on the other hand, his physician, Dr. Gold, was both attempting to develop the patent line and actively treating the patient for hairy cell leukemia at the same time. So he was doing the intervention and interaction on identifiable specimens. So that was human subjects research. I should be clear that the common rule, I think, is not promulgated formally until 1991, I think, in its sort of modern form. So this did not govern that case, but the sort of frequency with which those things arose led to the need for regulations like this. So here are some of the definitions for what an intervention is or what an interaction is. Physical procedures by which information is gathered, manipulations of the subject or the subject's environment, interaction, communication, or interpersonal contact between the investigator and the subject. So there are a whole range of times when IRB review, well, I'll start with when IRB review would be required, and they're largely contingent on that distinction, the intervention and interaction distinction. So prospective collection of biospecimens for a specific research study. So you know you're doing research, you have a research question, your purpose of interacting with the patient is to obtain data for the research. Prospective collection and storage of biospecimens for future use. So you know that's why you're collecting them. Secondary use of identifiable biospecimens. And I think this is a really important distinction for us to make for clinicians who are doing research or for researchers who are relying on clinicians for their biospecimens. There's a whole category of biospecimens that become available because they are the sort of waste, leftover, or refuse of clinical diagnostic procedures or care. So an example of this that I use frequently would be a pregnancy HCG test. So a woman has a home pregnancy test indicating that she may be pregnant. She comes in to have confirmation with a blood test. The blood test indicates that she is pregnant, and the waste of that afterwards is sent to somebody who's doing research on biomarkers for stress or something. Who knows what it is. And that secondary de-identified use would not fall within this category requiring. It would not constitute human subjects research. So, so the identifiability of the subject becomes the critical issue for a lot of this. Secondary use of coded biospecimens if the investigator has access to the code. Secondary use of de-identified biospecimens in a project that will generate data for the FDA, and testing and efficacy of diagnostic devices using de-identified data. So examples, we kind of talked about this by default, examples of research not requiring IRB approval. So this is your first category, right? Collection and use of biological specimens obtained through standard of care clinical procedures. So a patient who comes in and has a biopsy of their cervical cancer, a patient who comes in and has a blood HCG test, those kinds of things. The waste or remnant of that specimen can be used in research if it is de-identified, and that is not human subjects research. Secondary use of de-identified coded biospecimens when you don't have a code, and they use the biological specimens from deceased individuals in a project provided the project will not generate data for the FDA. It's interesting to note in the Henrietta Lacks case, this is just a little bit of an aside, that there were concerns about consent even in her case. And the autopsy of her case was limited. Her head and her brain were not autopsied because the family would not consent to that. So there was some understanding of consent even within that context, which I think is kind of interesting. I think my URL at the bottom there is no longer an active URL, so I may have to fix that later. Yes.
Clarifying question. What is the role of the FDA?
I don't, so the FDA is not, I don't know, I'll be honest with you. Maybe if somebody else in the room understands the FDA exceptions to this, but.
John, can you tell us? I think the FDA is not party to the common law.
I think that's right.
They have their own rules, right? Yeah.
But there are 16 agencies that are parties to the common law.
Are these a mix then that don't count as human subjects research versus ones that are exempt from review? Isn't it a mix? I think the first one is not human subjects research left over. Can they be identified if they're left over? It's interesting details on this, right?
Yeah.
About which kind of biospecimen research can go forward with no consent from the participant.
Right. And then I've left out of here the issue of waivers of consent, which is a sort of, in the interest of time, but obviously there would be human subjects research for which you could get a waiver because of what really amounts to a practicability problem with consenting under certain circumstances. But I didn't focus on that to stay within time.
I think the second bullet point, the first part, if it's de-identified de-identified samples, then it's not human subjects research at all. Whereas if it's a coded biospecimen where you don't have access to the code, then it's the subject of it.
Oh yeah.
So either way, though, you don't have to get consent.
You don't
get a key take-home point for people who are watching this talk.
Yes. You do not have to. Yeah. You do not have to get consent.
John says I'm right.
And so, and to be,
he doesn't say I'm wrong.
And again, to be clear, that's a distinction even from having to get a waiver. You affirmatively don't have to even, and you don't have to even, broach the topic.
Can I ask you a question? This is Andrew.
Hey, Andrew.
Yeah. So when you say de-identified biospecimen, does that what happens to the medical record that goes with that biospecimen? Is that part of the does that have to be removed completely, or is it just the identification of the person, but other information that goes with that specimen, age and weight or height or disease status or things like that, are those have to be scrubbed as well?
Yeah, so a lot of them have to be scrubbed. I think there are 18 categories of PHI under HIPAA that constitute identifiable information within the EMR. And so some of those categories will sort of instantly render somebody identifiable. So one of the interesting ones is individuals over the age of 90. If you have that marker on a specimen, that specimen is necessarily identifiable because the population of people over 90 is evidently so small.
Meaning live.
Yes.
Yeah.
Yes, living. And then the other categories include things like zip code, address, certainly social security number, EMR number. I can't remember all of them, but the general sort of guideline or rule that I've heard articulated, and I kind of like this, is that if you can use the various categories to easily triangulate a single person, then that specimen is identifiable. So if you think about something like zip code plus age plus sex on a biospecimen, those three things together probably make that biospecimen identifiable. And so the EMR, sort of an entire EMR traveling with a biospecimen is identified, right?
Right.
That's very clear. The question of which bits and pieces of the EMR you can attach to a single biospecimen without it being identifiable is a little bit fuzzier. Some things are automatic social security number, for example. Other things not so much. It sort of depends on the combination.
Well, exactly. And
yes, exactly. What did you say, Andrew?
Yeah, yes, that's what I was getting at, this complication, particularly so someone who has a particular disease state and their age or sex, and they're being seen at a particular clinic, even if the name and other identifying still might be able to be triangulated.
Yeah, I mean, so I always am a little bit hesitant to offer any sort of general rules at all here, because I think as we get further into genetic and genomic research, we're going to be able to identify either pathogenic genes or potentially pathogenic genes that are unique, or at least very, very rare. And so the mere presence of those would seem to make somebody identifiable. But that, I don't know that we're necessarily there yet. You might know, TJ. No, you don't know, or no, we aren't there.
Thanks.
Can I say yes, both?
So, but yeah, I agree with you. And I also, I mean, so the question you always get on the street is that isn't any blood sample, for example, identifiable because it contains DNA and DNA is unique to the individual. I mean,
So,
we'll see.
so that actually was exactly the reason for the proposed new common rule. They proposed that therefore any sample containing genetic material
Right.
could not be counted as de-identified. And that proposal for the new common rule was not carried through for
Right.
action, partly because the research is saying that's just going to make all this research
Impossible.
impossible.
Yeah.
There are other defenses you can make for saying that even though it is theoretically identifiable, there actually are steps that we needed to get the person obviously genetic data banks. And if you have those kind of resources for other data about them, you might be able to do that too. So,
Yeah.
But that's why they built it into the new common rule that every 3 to 4 years, they have to reassess
Yeah.
that identifiable biospecimens component.
But I wonder whether, I mean, this may be more of the discussion. I don't have very many more slides anyway. This may be more of the discussion, but I do wonder whether we're eventually going to get to a place where the identifiability of individuals by DNA is just actually really, really easy. And the example or the analogy that I might use for that is some people might remember the Ashley Madison hack. Do you remember that website? So that was the website that people could use to have affairs. And it was supposed to be anonymous, and you could, but somebody hacked it and identified all of the credit card numbers. And they were sophisticated enough that they were then able to create a map where I think they triangulated maybe ISP numbers with credit card numbers down to addresses and had pinpointed the addresses of individuals who had attempted to date through this app. So I can see how something like that would easily be able, in some future dystopian, not so future world, happen with DNA.
Well, there'd have to be a database of DNA to compare it to.
Yeah, or kind of. I mean, you get to some DNA that's rather specific, and all you need to go with it is a zip code.
Yeah, I mean, I was kind of going to say the same thing, also just as speculation, but you would, just having the DNA isn't going to tell you anything about a specific individual. You would still need some kind of a link,
Yeah.
unless it's highly specific. But there are those kinds of databases that are being developed, by all of us and the VETS project,
Yeah.
where those kinds of things are going to be widely available to something like the public in any case.
But it doesn't have to be a research enterprise or specialized, ancestry.com. And they've been able to, find people and arrest them based on relatives who have committed DNA to Ancestry or 23andMe.
So let me just get through, I think, 2 more slides here, basically, and then we can kind of open it up to some of these sexier topics. I mean, the bottom line here is to attempt to help some of our clinicians understand when they do and do not need consent for the research they're doing in their clinics. And I think the sort of nail to hang your hat on with that is it depends on the extent of your interaction with the research subject in those situations. So if your research does constitute human subjects research, the elements of consent that are required are fairly detailed and extensive. So this is just a summary. This is not verbatim. This is just a summary of the requirements for research in the common rule. So if you are doing human subjects research, you must obtain a detailed consent that includes a statement of what the study is and foreseeable risks and benefits and alternatives and all this other stuff. And in addition to that, if it's going to include an identifiable biospecimen, you must have these two additional elements of consent, indicating the potential for future research and those sorts of things. A brief note on broad consent. So if you're going to use a broad consent for potential for future research, you must have all of the elements of the standard informed consent plus these additional 6 pieces of information, which include contact information of an individual who can answer questions, which I think is really important once we get into research on biospecimens, which people largely don't understand. So, so the place where I kind of end up, back where I began, is this language in the general consent, ubiquitous in academic health centers, that purports to consent to research in a clinical setting. That's where these folks receive this document, right? I mean, they are not recruited to research and then get this document. They are there for treatment and sign this document. And so my conclusions would be that there are really 2 pathways to research in a clinical context. One involves human subject research, where you have to comply with regulatory requirements for consent as set forth in the common rule. And therefore, these sort of combo consent to treatment, consent to research forms would not be compliant. They would not satisfy those requirements. They would not satisfy the requirements for informed consent. The other pathway to research in the clinical context, or arising out of the clinical encounter, however you want to think of it, would be non-human subjects or exempt research, in which consent is not required at all. So the combo consent forms aren't necessary, including a consent to research under those circumstances doesn't seem to make sense.
I have to be careful about the exempt, because recognizing that consent is a process and not just a document, given that we're accredited, we do require a consenting process for exempt research.
So even knowing that would be fine, but this form would not be that.
Yeah, no, absolutely not.
So where I end up in terms of my sort of practical advice to our clinicians is that I hope they are not relying on this form to do their research. I think they are largely not. And that I hope that as an institution, we sort of heed our patients' objections to being confronted with a sort of kind of consent to research when they're there for a treatment encounter. And it serves as a surprise, a sort of unpleasant surprise to them. And I think I did that in 20 minutes. Did I?
If you take out the questions, you very much succeeded as always.
All right.
A+.
Thank you.
Okay, great leader, right? Questions and thoughts about this?
So
Yeah.
Can you go back to the last slide? So the right side, people are surprised when they hear about it. Not even the right side. People are surprised when they see the consent form or even do research on it. Could that language be useful though in preventing them from being surprised later if they find out, like, oh, you were doing research, you didn't even inform me? So your objection is that, well, that's not actually consent to why I'm doing it, but at least that it confronts that up front.
So I kind of like, yes, and I kind of like the language that's used by Northwestern. I think this probably gets at that happy medium that you're talking about.
To me, that's a little different than what IU Health and
Well, it also doesn't cover. You could have human subjects research, review of medical records,
right?
Which they won't contact the person. That says we'll contact you to discuss research opportunities.
Right.
That's different than saying we're going to access your medical records and do for purposes of research.
Yeah.
So this is just saying if we're going to call. This is like that in research, right? You sign up for it and they contact you with research opportunities to participate.
Yeah, I don't know. There's
Yeah, no, I like what TJ is saying here, that basically it's a reconceptualization of what is being put on the general consent. We don't need your consent to look at the identified information about you. researchers can do that without your
Yeah.
consent. We don't need your consent to use your leftover samples.
Right.
It's trash, and we can look at it and move on with it.
It is.
So it's not a matter of consent, it's more a matter of, hey, heads up, you're part of a healthcare system, it's a learning healthcare
Yes.
system. Like when you come here, there are things about you that we will do to protect your identity, and you will not be involved in research. But other things will happen without you having to be asked.
But,
So I think
but need to modify your thing though.
Right.
We also can access identifiable information without consent
Without consent. For research.
for research.
Wow.
When?
Expedited categories 5.
Right.
Oh,
And now exempt category 4, secondary research, as long as there's privacy and things like that are taken care of.
Right.
So we have prospective, identifiable medical record research.
so I want to get back to this though, this issue though, because this becomes important to me too. So for research, that one of the fundamental sort of issues is voluntariness. And so one of the questions that I would have about this particular form is whether somebody who is there for treatment and has to sign a consent for treatment that includes a consent for research can be said to be voluntarily agreeing to that research. I think there's some questions about whether these forms, which include a lot of information, are voluntary as to any of it. But certainly, if we prioritize voluntariness in research and you're there for treatment and have to sign a form, it becomes, I think, a problem that way.
There's something similar, I think, in this instance too, like the ACMG opt-in, opt-out controversy from like 2013, 2014, where the American College of Medical Genetics and Genomics said that you had to return, if you were going to do a large-scale genetic test, you were, as a researcher or as a within clinical settings, you were required to return specific genetic information back to the participants that had nothing to do with the original reason for the testing. And the original statement said that there was no opt-out option. If you were going to get a large-scale test, you had to also receive information that wasn't related to your present condition. And then there was a huge backlash to that then ended up with them sort of rescinding that recommendation, saying there was an opt-in model then. And I think there's something really resonant with what you're saying right now, with if you're bringing someone into the ER and saying, do you want to receive life-saving treatment? If you do, you have to sign this thing that says we're going to do whatever we want. What's the coercive aspect of that? And I think the ethics consensus on the ACMG thing was that wasn't sufficient. Yeah.
So the language in law would be sort of adhesion contracts, where the bargaining power is so uneven and the need is so great for whatever it is that you're seeking that the contract could effectively say anything and you would sign it. And so those are generally frowned upon as being, unfair, impermissibly unfair. So, and there's an interesting, I didn't get into it here either, but there's an interesting history to treatment consent forms, specifically which arises out of surgery and the inherent sort of risks and dangers of surgery compared to if you needed surgery, you must be in really bad shape, right? So you desperately needed it. The oldest consent form that we have record of is a consent form from the Ottoman Empire in the 15th century, indicating that somebody will have their kidney stones removed, and if it goes poorly, they won't sue. So I think that, is kind of, go ahead.
This is very tangential, but in a lot of, I think it's sub-Saharan African Bantu witchcraft practices, there's also an acknowledgement that if there is a failure of healing witchcraft, it's not the responsibility of the witch.
Which seems right.
Yeah.
Which does. So let me say something about what you're raising here, James. So you're right to say that we want voluntariness in research participation, but I think the idea to defend, if you want to defend this disclosure and the continued requirement that to receive care, you will be subject to this kind of research interactions, is that everything will be, you'll be being very well treated, right? So it's like using your data. It's not to say that because you want to come in to get treatment for your cancer, we will put you on whatever thing we want for research purposes, not even for the care, and you can't say no to that. That kind of contract, I agree, would be horrible, you would throw it out. But to say we will look at your data, protecting your privacy tremendously in cases where we think there's no risk to you of us doing that, or we'll use your leftover samples. In those cases, I think you say, well, look, by making it automatic on the basic care treatment, that's violating voluntariness. I think I would say, maybe just as a devil's advocate, say, well, of course we would. Of course we can give you voluntariness about that. That's not what we're talking about. We say we're defenders of voluntariness of research. What do you mean when you take on risk to help other people, help other people, basically? In this case, it's just a byproduct of your care. There's no risk to you. And we will do this, and we'll let you know as part of the deal.
Yeah.
Do you feel better?
Well, you mean, so my approach to research anyway, like I agree that the public has an ethical obligation to participate in research. Whether we can impose that upon them through the treatment context, I think is a question that is a little bit dicier. And I think your example that you give of the sort of like, hey, you come in for treatment, we treat you really well, you're at an academic health center, that to me has echoes of the sort of exploitative history of autopsy medicine. The idea that the impoverished will come into the university affiliated hospital and our physicians will learn on you through autopsy, which is, led obviously to enormous discoveries and advances in medicine, but also is seen as perhaps exploitative of people, of the poor who are seen in those hospitals. So, but always the balance.
I wonder how much of this is really a problem of using the same language in two different contexts. Because no research institution would treat signing something like that as consent to participate in a research project.
And yet, it's there.
Not with, it's there, but it never is a standalone consent.
Right.
Whenever research is taking place. So the question is what purpose does the hospital have in saying this?
Right, that's exactly my question. I mean, that's exactly what purpose
Not
does
going with
this.
the university, not the hospital.
Yeah, I'm not sure they're so different, but that's exactly my point. Is what is the point of this language that patients don't like and that doesn't seem to operate in any real protective or affirmative or informed way?
I mean, I think it makes perfect sense to tell people you're coming into an academic medical center, you may be approached to participate in research. There may be some research that takes place involving your medical records and leftover specimens for which we won't be contacting you specifically for. But there's still a review process for those to take place.
I think that's closer to what some of these other ones are saying. Yeah. And these are single paragraphs pulled out of longer documents. So there's
that's the next thing, right?
Yeah.
So I'd be more concerned not so much what these sentences say, but if it's buried in a 5-page general consent treatment,
it doesn't.
then who cares what it says, right? It's not being looked at all. In fact, you would say if there is a defense of this sort of language as disclosure, not as consent, right? So it's like the purpose of it is to help people understand something about how this hospital works, not to ask them for permission. It fails on both fronts. It wouldn't be good to ask them for permission because it's and it's not good for disclosure either because nobody notices this except for your lawyer who redlines it.
Yeah, which is exactly the kind of stuff.
But not so many people, right? Thousands of people.
Not thousands. Yeah, not a ton of people.
But I wonder, I mean, would it make a difference? I remember when HIPAA came into being, that all of a sudden we've included this type of information in the HIPAA form, not in the agreement to treat form.
No, it's still in the agreement to treat form. It's not.
Well, I don't know. I'm not saying we, meaning IU Health. I wasn't here then. But you're working with some critics. That's when they put it in. They put that we revised created the privacy statement and included it there. And the absence of including it there might have precluded the ability to use the medical records without individual permission.
Yeah, I remember when HIPAA came into being too, because it frustrated our ability to subpoena medical records. And it shouldn't have. I mean, HIPAA covers that. But people didn't know how to use it, you know, in those contexts. And I do recall, I mean, HIPAA is pretty specific about like the information that specifically has to be contained in a release to medical documentation. So I assume that those are just bits and pieces of that. So.
2 points of historical points that you might want to delve into. One is the Henrietta Lacks, right? There were 2 samples collected from her. One was during the clinical examination of her cervix, which was then sent and cloned. Most of, I'm not sure exactly, but from what I remember from the book, it's been a couple of years since I read it, that they think that the HeLa cells came from that sample.
Yeah.
But then when she died, her family was asked for an autopsy with consent to research use of her tissue. Her husband initially said no, and a cousin got him to say yes. So in that case, actually was sort of pretty forward-thinking, complete consent, but it had all the drawbacks of standard consent, which is that he was pressured into it.
Yeah.
So again, as you say, consent is a process, not a form. In this case, you perform without a very admirable process. John Moore, the insight John Moore, which is interesting, is that he kept being invited back for samples which were not treated at all. So I'm not sure he really falls in your.
Well, so he doesn't. I mean, he
the first
falls.
one was, but then the later ones, when he figured out something was up,
Yeah.
he said, yeah, they came back, they handed him the research form. He said, I'm not going to sign that. He put it aside, right? And they called him later and said, we noticed you didn't sign that form. We'd love to have that in the mail. We're going to send it to you, okay? And they sent it to me, he didn't fill it out again. And then,
And yeah, so I mean, I use him because of the lack of distinction between the clinician and the investigator. That's that's sort of the sort of quintessential example of that gone wrong.
love it.
Other questions? And that's why the new common rule has that new requirement of informed consent, that if you're taking biospecimens, you have to identify if you're going to do any commercialization, whether or not the subject will or will not participate in the profits. I get to see one that says it does.
So my students hate it, but I do agree with the court's analysis and more as to the policy reasons to not compensate participants for that stuff. I think they're right on that it would make research, it would discourage research, and for some research, it would make it impossible.
Do people object to that, to the teaching on it? So it's going to be used for teaching or research?
No. I mean, not as disruptively or as aggressively as they.
It's not that we're using their data, it's specific for research.
I think people maybe have I don't know, maybe I'm reading too much into it, but I think people have a general sense of what a teaching hospital is, or they get it after they've been here for a while. Oh, right, the medical student's going to take my history. Oh, resident's going to see me first. There's some sort of general sense of that. I still, as we were talking about yesterday, I don't think people really understand how extensive and pervasive research is here at every single level of interaction with the patient. They can't even wrap their heads around it.
2 things. One, in direct response to TJ's question, I remember when I was doing the McLean Fellowship, we had a long discussion about patients being frustrated by the teaching portion of it, where they didn't realize that there is going to be 1 million students coming into their vaginal exam, for instance. So I think that there is frustration and also ethical issues involved in that side of it too.
I agree with that. I haven't seen much of it at the sort of intake process portion of it. And I also, to your point about that, I can remember when my daughter was delivered, and some of you know she has a congenital heart defect, and there was a resident who just kept coming into the room, like now, like just so excited to see this kid who was going to have born blue. And I could have done without that, right? I could have done without that. So I think part of that can be mitigated with some good mentoring. Whereas I don't know what you do about helping people understand the research that's being done on them.
Yeah, I think some of the teaching aspect of it is fundamental to the teaching process, though. Like having vaginal exams, which are invasive, and I think a lot of people are not interested in having other people observing that, but that is also necessary, and you can't have both.
Yeah,
Oh,
I'm
yeah,
gonna
so,
leave that.
so we're,
for now.
well, we have a continuing evolution of medicine over whether patients know that there may be trainees on the treatment team who would perform the pelvic exam, perhaps even under anesthesia, and probably not enough progress has been made worldwide, nationwide, at making sure patients know about that and opportunity to choose about that. Okay, I will tell you, there's a pitch that you said, well, I don't know how to fix this in terms of understanding. One of our other truth talks, which is on our website by Mary Ott from about a year ago about quality improvement versus research.
Oh,
She
yeah.
delves in at the end of that into a very interesting area of research for us at the center and within BSAP on learning healthcare systems. The idea of you actually promote the idea of, say, learning healthcare system, where when you measure, it's not just about your care, it's about collecting data and moving forward on understanding successful treatment of the population. Just what you said, it's like ethical.
That's one of the
obligation.
Princess and Fame Children's papers.
There's some good writing lately and some mission research being done here on how to do that. Right. Right. It's almost like, and I've said this to the PR people at IU and IU Health, I'm not sure if they're going to listen to me, saying we should be championing and advertising the fact when you come here, you're part of a research enterprise. That's why you should come here. You're part of this great institution that's moving forward, protecting your rights and taking care of you, but also moving forward with research. That's a pro. That's something to mention in a 15-page document. It's going to put on the billboard. And I don't think people are worried about saying that, whether it be a pro or a con on attracting patients to a place like IU Health. So, excellent.
So you think embrace it?
I'd say embrace it. Run toward it instead of trying to hide it. And this is about exposure.
That's all I got. Thank you
Thank
very
you,
much for
Jane,
coming.
so much. It's right under